Welcome back to Court TV Live. Thank you for being with us. I'm Julia Janae along with Ted Rollins on this Monday afternoon, and we're beginning this hour in Tennessee. We are watching a hearing that's been going on for a long time in the murder of Holly Bobo case.
Zachary Adams was found guilty in 2017 for kidnapping, raping, and killing the 20-year-old who had disappeared from her home 6 years earlier. The defense is now trying to get a new trial based in part on testimony from a man named Jason Autry, who now, after testifying at trial, says he was lying about Adams killing Holly Bobo, and the defense is saying that was massive. That was key in this conviction.
So Adams, who was looking for a new trial, he also took the stand last week. We showed you that here on Court TV, where he slammed the attorney that was representing him at trial.
We met a lot, but we met a lot, like the discovery. I never got to see all the discovery. Like, she tried to fix it up at the Williamson County Jail where I could get a computer and get the hard drives, and the sheriff, there wasn't trying to make anything extra, special for me. He said, no, you can get it mailed in. What the sheriff didn't realize is it would have filled 4 or 5 cells up. And I never got to see all the discovery. I never, we met a lot, but a lot of it was just, she just asking where I was, she was unorganized, very unorganized.
So, being a part of this post-conviction relief process, observing Mr. Bates and I.
Day and night difference.
So, knowing now, if you had known then what you know now, would you have testified?
Absolutely.
That was a big part of his testimony on the stand, saying he wanted to testify. His attorneys convinced him not to do it.
Ineffective assistance of counsel is what he's claiming. And we're going to hear from that attorney on the stand. That former attorney is going to be on the stand, and we'll watch that.
Yeah, all right. Before we do that, let's get more on the case against Zachary Adams.
First-degree felony murder of Holly Lynn Bobo during the perpetration of or attempt to perpetrate kidnapping of Holly Lynn Bobo. You checked guilty of first-degree felony murder of Holly Lynn Bobo. Is that correct?
Yes, sir.
20-year-old Holly Bobo disappeared from her home in 2011. 6 years later, Zachary Adams was convicted for the kidnapping, rape, and killing of Bobo and was sentenced to life in prison, thanks mostly to the testimony of this man.
Jason Autry, Jason-Autry.
Jason Autry testified at trial, recounting the day Bobo was kidnapped, claiming Zachary Adams and his brother wrapped Bobo in a blanket, placed her in the back of a pickup truck, drove her to a river, and shot her.
And I grabbed the upper torso of Miss Bobo. Jack come around, let the tailgate down. I brought the upper torso to the end of the tailgate.
But now Autry claims he made it all up. He sat down with Nick Barris at Scripps News Group Nashville before the trial to say this.
Make no mistake, Jason Autry is a liar. He told 2 stories, and the question now is, which one to believe? The answer will decide if a convicted killer goes free. And all of a sudden, Jason Autry is saying he made everything up, that he was able to make up all those details because his attorney provided him discovery. And with that discovery, he was able to sound very convincing at trial.
Zachary Adams is now appealing his conviction due to Autry recanting his testimony in hopes he will be granted a new trial. And that's what brings us to this evidentiary hearing that has been going on for months. They keep pausing it for different segments. So this is all in front of a judge, not a jury, but they are calling witnesses to the stand. There's direct and cross-examination. Let's go into court now. Adams's defense attorney is on the stand. This is the one who represented him during that trial where he was convicted.
And now, can you go to the end of his direct on page 1624?
Yes.
Question by General Hagerman, was there pressure to solve this case? Answer, self-imposed. Yeah. There's pressure. That's my friends and neighbor. You don't get in this line of work for the money. I don't do what I do for the money. I do what I do because I love people. I fix things. I am a hands-on kind of guy. Take charge and fix things. What's solving this case mean? Does it mean just picking somebody? No, because there's all this pressure being self-imposed. No, I would never do that. We never would do something like that. We pride ourselves on doing the right thing.
Is there a question for Ms. Thompson here?
Yes. If I can get to it. We pride ourselves on doing the right thing and always the right way. We make mistakes in this one, yeah. One I'll take with me the rest of my life. That's all, excuse me. But I got the right person. I didn't charge the wrong. Then you objected, line 23. Objection, Your Honor. I object. We're giving opinion testimony right now. I object to that. Then, General Hagerman, I think it's enough. I'm not going to ask any further. Thank you, Agent Booth. And the court said cross. All right. Do you remember this part of the trial?
Yes.
Do you believe Agent Booth opened the door to whether he did things the right way?
Yes.
At the time, you had the recording of Agent Booth and Victor Dinsmore just several months before, correct?
Yes.
You did not hit him with that on cross-examination, did you?
No, I didn't.
You did not hit him with the Dylan Adams interview that he could have authenticated because he was there.
No, I didn't.
You agree he could have authenticated it?
Yes.
You could have gone through Jeff Jackson's behavior against Dylan to get a statement the state said they don't believe.
Yes.
Why not?
I don't know. I think I was overwhelmed at that point. I think that we didn't know who was coming to testify. I should have also in advance, not just the night before, but in advance should have sat down and gone over these things and really thought out how I could get this material in. I don't know why I didn't do it. I can't explain it.
Do you think that was competent counsel?
No, I think I should have put it in. I think that the fact that the TBI was willing to go with one lie when it really didn't meet the facts, and then they were willing to go with Jason Autry's lie, which didn't meet the facts, would have been telling.
The jury never heard any of the Dylan stuff, did they?
No.
They had no idea there was a 4-hour interview that the state traveled on for how many years?
2014, 15, 16, so 3 years.
You didn't ask Agent Booth if he felt he coerced Victor Dinsmore, did you?
No, I did not.
Did you ask Agent Booth whether Victor Dinsmore told you what kind of gun it was?
No, I did not. I don't think this is working.
Do you understand the importance of the timeline of that morning as it relates to a window for a white truck to be hidden at Victor Dinsmore's?
Yes.
What is it?
Well, it's going to take them 30 minutes to get back to, from the river to Shane Austin's house.
On what alleged route?
On really any route, unless it was the interstate, and Jason said they didn't take the interstate.
What was the importance of not taking the interstate?
Well, because they didn't want somebody to see the dead body in the back.
If they took the interstate, what would the significance be?
Well, they would have gotten back faster They might have gotten back in less than 30 minutes.
Would they have had a body in the back?
Yes.
You think they would have driven the interstate with the
Your Honor,
body?
to the speculation.
Fair enough.
All right. Objection sustained.
Did you had your investigator run the routes from the alleged spot Zach and Jason were at the river?
Yes.
And do you remember the belief that there was enough time to get from the river along Autry's route back to where they were at Austin's house at the time frame they provided?
Before 11 o'clock?
Yes, ma'am.
Because Jason had to go eat
Yes.
lunch with his girlfriend at 11. I don't think there was enough time, no.
What route do you think they actually took?
Well, they didn't go. There's no real route. They didn't do it.
Do you understand at some point you understand where the cell records put Dylan, Zach, and Shane in Parsons that morning?
Yes.
What time?
11:20,
Okay.
I'm guessing. I can't quite remember.
Do you understand what was your understanding of the state's timeline when a truck was hidden at Victor Dinsmore's?
I don't know what the state's timeline was. I'm guessing from Victor Dinsmore's trial testimony, the state saying they did it before they went to Parsons.
Did you explore when there was time to do that?
No, I didn't. I should have.
Did you discuss with the jury this timeline that the state was bound by?
No,
Why not?
I don't know.
Do you remember having discussions with your internal team, Mr. Simmons, your background investigators?
Simmons didn't discuss any of it at all with me during the trial, I don't think. The investigators, I don't remember specifically. I remember showing that they couldn't get there within the 30 minutes that Jason said, or it would take them over 30 minutes. And so that Jason's timeline was off. I don't specifically remember putting the truck being hidden at Victor Dinsmore's, moving tires, getting it in there, and then going to Parsons by 11. I don't think I specifically remembered that or put that together.
Did you emphasize to the jury the cell records?
All right, let's get a commercial break in here. When we come back, Thompson says she didn't realize how much everybody was going to lie at trial. That's next.
Tonight on Closing Arguments, tragedy on a cruise ship after the body of a teenage girl was found under a bed. We'll bring you new developments in the death of Anna Kepler.
Closing Arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV.
The disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage begins December 1st on Court TV.
I'm just going to speak to the elephant in the room, okay?
Okay.
Did you know Holly Bobo?
No, ma'am.
Did you have any knowledge of the Bobo family?
Miss Karen Bobo was my fourth grade teacher at Parsons Junior High School in middle school.
Did you kidnap Holly Bobo?
No, ma'am.
Did you rape Holly Bobo?
No, ma'am.
Did you murder Holly Bobo?
No, ma'am.
Did you have anything to do with the disposal of Holly Bobo's remains?
No, ma'am.
Back down to Tennessee, where convicted killer Zachary Adams says he didn't do it. He didn't kill Holly Bobo. Well, he was convicted of it, and that's a big problem. And he's asking for a new trial, saying that his lawyer didn't help him, and that a witness, a key witness in this case, lied. And for that, he believes he deserves a new trial.
And that is huge. I mean, that does not happen in every case. The victim here was a 20-year-old nursing student, Holly Bobo. She disappeared from her home back in 2011. And 6 years later, Zachary Adams was found guilty by a jury of kidnapping, raping, and murdering her. And he was sentenced to life in prison, thanks mostly to that testimony of Jason Autry.
Now, Autry says, I was lying. And he said it on record, so here we are. You know, let's face it, Adams has gotten to a point where a lot of people don't. You know, there's tons of people sitting in prison cells saying, I want a new trial. Well, he has a real opportunity here. And let's go back in. He blamed his lawyer. Well, now his lawyer, who he blamed for not representing him well, is on the witness stand.
From 10:49 beyond.
No,
Why not?
I don't know.
You remember, do you remember Jennifer Nichols' examination of Victor Dinsmore?
I've recently reviewed it.
If you could go to page 1536.
1,536?
I apologize. It's going to be sooner than that. 1,490. 1,505. Final answer. Let me know when you're there.
I'm there. I haven't reviewed it yet.
Line 17, question to Victor Dinsmore. And while they're on the property, did Zach make statements to you about speaking to your wife or going to your wife's house and putting a car in your shop? Answer, no. He did not say anything. No. At any time did he tell you that? No. Then it continues 1506, but you don't recall him mentioning it there on the property. No, I don't remember him saying anything. I was trying to get them out of there before Mr. and Miss Doug or Dottie showed up. You recall, of course, being interviewed by law enforcement several years after this happened, correct? Answer, correct. And in that statement, just a minute, in that statement, if you told the, and then there's some objections, it continues on 1507. Question line 3. So my question is, did you make the statement to TBI Agent Trout that Zach Adams hit his grandfather's white Nissan post-abduction? Yes. Do you remember this?
Yes. I mean, first of all, it's terrible. She's leading him terribly. He's asked and answered and said he didn't remember. I mean, the objections I should have made to that, but
Did you
it's
have
hearsay.
Did you have Valerie Trout's statement, IR statement?
I probably did, but I don't remember.
Did you have Valerie Trout under subpoena?
No, I did not.
Are you aware of Rule 803-26?
That prior inconsistent statement?
Yes.
Yes, I reviewed it last night.
Okay. A statement otherwise admissible under 613B if all the following conditions are met. The declarant must testify at the trial or hearing and be subject to cross-examination concerning the statement.
You know, if she's testifying, she's familiar with it.
All right. Was that met?
Yes.
Were the other conditions met?
Yes.
Why did you not then go to your computer and show the jury the Brent Booth, Victor Dinsmore conversation at that point?
I don't know.
Was there any strategy involved in not showing that to the jury?
No.
Anything that you think's not, that was hurtful to Zach, you didn't want to present?
No.
Victor Dinsmore prior had said that at the fight in the afternoon of April 13, 2011, what did Victor Dinsmore said they were arguing about? Do you remember?
I get confused. Did he say that they were arguing about who was going to hit that, or he'd let Shane hit that?
Was it your understanding Mr. Dinsmore was referring to a future event against Miss Bobo?
Yes.
In this recorded statement, do you remember what Brent Booth said Miss Holly's condition was at the time they were arrived that afternoon?
I think he said she was dead.
Does that make Victor's statement make sense?
No.
Why didn't you present it to the jury?
Gosh, I don't know, Mr. Bates. I think, at the time, I should have had this all prepared out in the beginning. I didn't realize how much everybody was going to lie. I thought that I would be able to use the cross-examination of their prior inconsistent statements against them, and I thought that they would just admit that they'd made these prior inconsistent statements, but everybody just lied about it and said they didn't remember. Usually in a case like this, the state goes over the witness's prior statements so the witness will testify consistently. But in this case, witness after witness was saying, no, I didn't review my prior statements. So the state hadn't gone over it with them to review their statements, and they came in not remembering, some of them not even remembering they had given statements.
Hitting the pause button on this testimony, let's bring in our guest to talk about this. We have with us trial attorney Mackenzie Joy Brennan. Mackenzie, this is an awkward situation for this Tennessee lawyer to be in. It's one of the worst probably that attorneys in their practice want to see coming. They don't want to see something like this coming where they have to defend everything that they did at trial. What are your thoughts on her testimony and if she's helping the defense or hurting?
Yeah, I'm so curious about whether there are disciplinary proceedings on the table here, if they are tied at all to what's going on with her admissions and whatnot, because a lot of what she's saying, she's very self-deprecating, if you will. A lot of, gosh, that wasn't competent, I should have done X, Y, Z, really owning up to things that may or may not consist of being worthy of overturning the conviction, but a lot for her job as an attorney. Now, that being said, it's a really high bar to prove what he's trying to prove here, which is that but for that testimony, the now recanted testimony from Autry, it would have been a different result. And for a public defender or anybody in her position to say things like, we were overwhelmed with e-discovery, we didn't hire the ballistics experts that we could have, that is so common for somebody in a defense attorney's position. It reminds me kind of this social worker who misses something before a child abuse tragedy, that it is so common to be under-resourced in these jobs that they can't hold everybody responsible just for not doing the absolute most that they could have.
Yeah, and then on the back end, when something does happen, or in this case, when someone's credibility is in question, here you are, you have to answer for it. Now, a lot of lawyers that are in this position, if they truly believe in the innocence of their client, they will take the hit, and we may be seeing this, because she, to your point, she's not defensive. She's not saying, oh, this is nonsense. She's admitting things, and she might be doing it for that greater goal because she believes in her client.
Yeah, I thought the same thing, that she may be kind of carrying through, ironically, that zealous representation and taking the hit. As you were saying, it would make a lot of sense. And that's why I wonder if there are disciplinary proceedings on the table, because that would be the biggest risk if she were to admit to too much and then it be enough that a conviction is overturned. That really would be a spot on her record that may not justify carrying this through for the client's innocence. So competing interests there. We'll see what wins out and what the outcomes are for both of them.
Yeah, we absolutely will. Mackenzie, thank you for that analysis. We've got to get to our break. When we come back, we'll have more of this case. Plus, we are paying attention to Wisconsin, Morgan Geyser, a situation where she took off her monitoring bracelet. This morning, she is in custody, and there is a police presser that is coming up soon. We'll have the latest after this.
Court TV Live, we are going to switch our attention now to the state of Wisconsin, where we are awaiting a press conference in Waukesha, Wisconsin. This is where Morgan Geyser, of course, was prosecuted. This is where the attempted murder case in that Slender Man horror case from years ago all took place. If you haven't heard, she was in a group home in Madison, Wisconsin, and last night she cut her bracelet off, basically her monitoring bracelet, and was apprehended a few hours later just south of Chicago in the state of Illinois. So we're waiting for more updates. There's a live look at the podium inside that building, or inside that room in Waukesha, Wisconsin. So as soon as they take the stage, if you will, we'll head in there and see what they have to say in terms of an update. What happens next? It's, what do you do now here with this young woman that basically has violated the conditions of her parole, which her advocates, including her attorney and family members, fought so hard for?
Yeah, we heard from that attorney during this time where she was missing and no one knew where she was, except for that she was with an adult acquaintance, is how it's being characterized. And her attorney taking to social media to say, turn yourself in. Looks like we may be having some movement there inside of this area there in Waukesha County. Let's listen in.
And sit on the public information officer here with Waukesha County. District Attorney Leslie Basie and Assistant District Attorney Abby Nicolai are here today to go over Morgan Geyser's procedural timeline and potential next steps here with Waukesha County. Any investigative questions you have about what happened over the weekend in Madison should be directed to Madison Police. So I will bring up District Attorney Leslie Basie first to kind of talk about her reaction to what happened with Morgan Geyser.
Thank you, Hillary. And good afternoon, everyone. I just found out yesterday about the escape, Morgan Geyser escaping from her placement in Dane County. As Hillary indicated, I'm not here to talk about that investigation. My understanding is that the Dane County law enforcement is investigating her leaving her placement and what occurred after that. What we do know is that she left, she cut off her bracelet, she fled to Illinois, which is where she was arrested yesterday. Any charges, as Hillary stated, with regard to the investigation from her escape would be handled by the Dane County District Attorney's Office. We are grateful for the efforts of law enforcement, not only in Dane County, but also throughout the area, because obviously she was taken into custody in Illinois and is currently in custody in Illinois. In terms of what happens from here, there is an extraditable warrant for her arrest. We are verifying with Cook County, which currently has Ms. Geyser in their custody, as to where we go from here. Our governor's office is also in contact with the authorities to see how they can best handle getting her from Illinois back to the custody of Department of Health Services, which is whose custody she has been in since she was actually committed by the court. With regard to what happens from here, once Ms. Geyser is brought back to Waukesha County, it will be up to Department of Health Services whether they file a petition to revoke her conditional release. We are certainly hopeful that they do proceed with that. We fully support it. We support that she should be in custody. Not only should she have been in custody from 2014 forward, but also Attorney Nicolai argued vehemently for her not to be released to conditional release in, I believe it was January of this year, and therefore we will be fully supporting a petition if one is filed. Obviously, our thoughts are with the victim and the victim's family during this time. It's unfortunate, but we found out yesterday morning about Morgan's escape. Victim witness was immediately notified of this information. The director of the victim witness unit, Jen Dunn, did reach out to the victim and her family. We were told that they had not been informed prior to Ms. Dunn reaching out to them that Morgan had escaped. And I'm able to verify that when we spoke with the victim's family, or when Ms. Dunn spoke with the victim's family at 12:20 this morning or this afternoon, they still had not been informed by any other agency other than our own that she had escaped, which is very concerning. While she was on the loose, we were very concerned about the safety of the victim and her family, as well as our community. We are continuing to assist them in this process. We are updating them. Our office is updating them as to what is happening, but that certainly was a concern that they were not notified of this in a more prompt manner. What we know is that there was a period of time between approximately 8 o'clock on Saturday evening to when she was taken into custody yesterday, in which she was not monitored by any person. She was on the loose and her whereabouts were unknown. So we take this very seriously. Our office will not get involved again in this case until a motion to revoke for conditional release is filed. We will then go back to court. We will fully support that motion and that petition to revoke her conditional release. And we will then go before a judge to make a decision on whether or not she will be returned to conditional release or whether she would be returned to institutionalized care, which is where she came from. And that's all I have at this time.
Can you file that motion to have her revoked or not?
No, the state, we cannot, Department of Health Services, per statute, has to file that motion. She is in their custody.
Can you appeal to them or talk to them and request that?
We are in contact with the Department of Health Services, but ultimately it is their decision.
So in March, defense attorney Tony Cotton said that a group home would have more restrictions in place than Winnebago. Was the DA's office receiving regular updates on Ms. Geyser's time at the group home? And if so, what was that day-to-day like and monitoring like?
I do not know what the monitoring was like. I don't believe that we received any updates, although I would confer with Attorney Nicolai. We did not. Obviously, he was misstating the nature of the monitoring that was taking place.
So the warrant that you're speaking of, is that issued by Dane County or the state, or?
The Department of Health Services did forward that warrant to our intake judge last night, and the intake judge, from what I saw this morning, did sign that.
So it's a Waukesha County warrant?
Correct.
Because DHS requested.
Correct, and because the case is out of Waukesha County, that's why it will come back to Waukesha County for the decision if a petition to revoke her conditional release is filed.
All right, I think that's a little why this is a little confusing, because there's a criminal, is there a criminal case in Dane County then? Is that a crime to cut your bracelet off if you're not under a criminal?
Certainly, again, this is a Dane County decision. As I looked at the statute, it looks like you can escape, be charged with a felony for escaping under a 971 commitment. Also, if there was damage to the bracelet when she cut it off, which I assume that there would be, that would be a crime as well. But again, that's outside Waukesha County's purview. That would be a decision. Law enforcement in Dane County, who leads the investigation, would refer charges over if they believed it was appropriate, and the Dane County DA's office would make that decision.
So just to clarify, I apologize.
No,
so the warrant that she would be returned to Wisconsin on would be a Waukesha County warrant. She would be returned to Waukesha County in custody?
That's what I believe, because it's still under the custody of DHS. But again, this is her home county for charging purposes. Therefore, I believe she will be returned to Waukesha County.
At any point down the line, could you guys press any other charges?
Not in Waukesha, unless we have jurisdiction to charge crimes that occur in Waukesha, and because she was in Dane County, they would have the jurisdiction to charge any crimes that occurred in Dane County. With regard to the conditional release, her violations of that order, which were as a result of a Waukesha County judge ordering it, that would be what would lead to a petition to revoke her conditional release.
And maybe Abby could speak to this, I'm not sure, but what is it that about her leaving as far as her being dangerous, I guess, or a danger to herself or others, which was the standard, right, that the judge went by, or at least that's what he said at the time?
Right. I think that one thing that is very concerning to me is that if and when a petition is filed by the department to revoke conditional release, it will be the second one that is filed, because we were here in March on a petition to revoke conditional release already. And so it's extremely concerning that you would so blatantly violate a very, very simple condition, which is to stay in the placement and keep a bracelet on. And that we have no idea what was going on is extremely concerning to the state, because immediately my thoughts went to the victim and keeping the community safe. But as additional information is gathered, that would be the kind of facts that are put into a petition to revoke, and that would be what is litigated at that motion hearing before the court, when I'd be able to gather more information, whether there are specifics about the dangerousness. But I think those blatant acts in themselves certainly speak to the dangerousness there.
There have been reports that there was a person in custody with her, or in her presence when she was arrested.
All right, there's more of this press conference. We do have to get to our break and hit the pause button, but if I told you so was a press conference, this would be it. The district attorney's office saying they knew this would happen. That's why they tried to stop her from that conditional release. Stay with us.
Tonight on Closing Arguments, tragedy on a cruise ship after the body of a teenage girl was found under a bed. We'll bring you new developments in the death of Anna Kettler.
Closing Arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV. This week.
Spend your holiday week with us. We're previewing the captivating trials that are coming up, and we're breaking down the biggest stories that are trending in true crime.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
Morgan asked me whether or not she should do it, and I just wanted it to be over with, so I said, just go berserk, do what you have to do.
I came up from behind her, I jumped on her, I tackled her, and I stabbed her. I just want to let Bella and her family know I'm sorry. Never meant this to happen.
That was Morgan Geyser in court when she was apologizing for the Slender Man's attack. Let's go back now to Waukesha County, Wisconsin, and pick up the press conference, and we'll pick it up right where we left off.
That person, where they played a role in her absconding.
We do not know any information about that person. That was information we had received, that there was a person that was outside the placement location, but I don't have any information about that at all.
But Abby, you were concerned at the earlier revocation hearing about people that were in touch with her even while she was still at Winnebago, correct? People, outside people that were contacting her, influencing her?
Right. There's a certain notoriety here that is of concern, that there are people that kind of sought her out, that there was some concern about communication with those types of individuals. We also had concern at that point with what seemed to be kind of a pushback in terms of Ms. Geyser's acknowledgement of the extent to which she'd be monitored, in terms of my reading material is going to be, that didn't seem consistent with someone that was ready to make that next step into the community.
But you have no way of knowing if this person was one of those that you were concerned about, was in contact with her at that time?
I don't know.
Would all of this happening impact a future request for a conditional release?
Certainly when those requests are made, I look back through the record in terms of assessments that have been done throughout the history of a case, and so I would say yes.
And just for the general public, I mean, because this isn't a sentence she was facing per se, but she still is under the control of the state, so there's leeway as to whether she is in custody or in state care in a facility or outside a facility, that type of thing. That's what you're talking about, trying to get her back to that previous level that she was inside Winnebago.
Right. Ultimately, if the petition to revoke conditional release were granted, she would go back to that institutional care placement, which would be a hospital facility.
Which is more secure, obviously, than
right.
Community-based facility.
Right, exactly.
Could you walk us back, just for clarity again, on the process of contacting the Leitner family once it was clear that Ms. Geyser had disappeared?
Certainly. I can tell you that I was informed yesterday morning about Ms. Geyser escaping from her placement. Prior to me even getting notification of that, I believe Ms. Nicolai and Ms. Dunn, who's the head of victim witness, also received that notification. Immediately, Ms. Dunn contacted the victim and her family to make sure that they knew about it. They did not know anything about it. We wanted to make sure that they were safe and that they had a plan in place. And I know that Ms. Dunn has been in contact with the family pretty consistently since then, offering services. And again, it was verified before we came up here that in fact, no one did contact them. Again, I would have expected that the Department of Health Services would have contacted them to let them know. Obviously, we want to safeguard her safety and the community safety, because frankly, when she's released based upon some of the evidence that came out previous hearings, we have concerns about the safety of the community as well.
Just for clarity, she was at that group home for, what was the duration? Was it September?
The judge, the final plan of placement was signed September 17th, I believe, and I'd like to take credit for knowing that, but again, Attorney Nicolai is the one who put together the timeline, and that was the time. So when she got to the facility, we're not sure, but that's when the court signed the order for the placement.
Looking back, do you wish that there would have been more communication between your office and a group home like that? Is that something maybe moving forward we would like to see?
Again, we're not, once the conditional release plan was signed, we really are not involved in the case. The people, DHS, they're the ones whose custody she has been given to. They would be the ones that would control that day to day. And again, I don't know what that communication is. It could have been a daily communication. It could have been a weekly communication. I'm not sure. You'd have to reach out to DHS to see exactly what that consists of. Again, our goal in our position is to hold people accountable. Certainly that's why Attorney Nicolai had advocated for the conditional release not to be granted, because that was part of the accountability and keeping our community safe.
Do you feel like there should be some mechanism to notify families in a case like this?
Absolutely. I've reached out to already some legislative personnel to see if we can't address that issue. I think that that's wrong.
Any other final questions?
Thank you very much.
The district attorney there in Waukesha County confirming that they don't know yet, in terms of the Waukesha County officials, who that adult was with the 23-year-old defendant, but that that's someone who would be investigated at this point for helping her in this escape.
Yeah, lots ahead here. You've got the situation in Dane County, that's Madison, where she was at that halfway house. Did she, was it a felony for her to cut the bracelet? Will she be criminally prosecuted there? Waukesha County clearly wants the Department of Health Services now to file a motion to revoke that conditional release and put her back at that hospital, which is just north of Milwaukee. A lot of places. She's still in Cook County, Illinois, in Chicago, so they're going to extradite eventually.
The governors have to talk about that because it's state to state, but it sounds like there's not going to be any issue there. But still a lot of questions when you had so many people saying she would be fine in this
And who helped her? That's a big question still.
We have to get to our break, but coming up, when we return, we are going to take you to Tennessee. We've been watching that hearing for Zachary Adams in the murder of Holly Bobo case. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us this afternoon as we start out a holiday week here at Court TV, and we're beginning this hour in Tennessee. We've been watching unaired testimony from last week's evidentiary hearing for Zachary Adams. It's been going on quite some time. He's a convicted killer fighting for a new trial, rather, after he was found guilty in 2017 for the kidnap, rape, and killing of 20-year-old Holly Bobo. She was a nursing student who disappeared from her home 6 years earlier. Now, during the trial, there was an important witness, this man named Jason Autry. He testified that he witnessed Adams kill Bobo, but years later, he's now saying that he made it all up. So, of course, Adams' defense is all over this. They are now asking for a repeal of his conviction, and it's based in part on this new information. But in a blow to their case earlier this year, the judge ruled that Autry's video recorded recantation could not come into evidence. So let's get you into the courtroom now. Where we are in this evidentiary hearing is the attorney who represented Zach Adams at trial. She is no longer his attorney, and she's on the stand as a witness because the defense says she was ineffective in her assistance. Let's go in.
Victor Dinsmore's cross-examination, page 1554. Line 16. Now, you also talked to Brent Booth about the gun that you disposed of that you got from Jason Autry, didn't you? That I had my wife dispose of. I got it from Shane. Your wife disposed of it because you suggested she dispose it, didn't you? Yes, I did. At first, you told Brent Booth also that it was a .357 or a .38, didn't you? Answer, yeah, I wasn't really sure what it was. Had you listened to the second recording of Brent Booth and Mr. Dinsmore when you cross-examined?
Yes.
Do you remember what Mr. Dinsmore said to Mr. Booth regarding the gun?
Not off the top of my head.
Your Honor, I'm going to play from the May 18th video recorded. Exhibit 64, the May 19th. We go to, what did we say? 17. Your question on page 1554 was a .357 or a .38.
Yes.
Why did you phrase it that way?
I'm sure that's because that's what he had previously told law enforcement.
I'm going to play beginning at minute 7:02 of Exhibit 64.
Huntington. She was going to the doctor in Huntington, so I told her to go up the river, on the way down through there. She didn't because there was too much traffic, came back, and that's when she pulled off onto a holiday road.
So I was just going to keep it and hide it somewhere home, and I thought, no, I have not to do that.
She was going to take it out of that boat that I had on the inside, put on my property, fill with dirt, push it out, pull it in. She was going to dig it up and put it in there. I kind of wish she would have now, because it'd be definitely sitting right there still. So
you pulled off to a holiday road,
and she
right there in the water.
And she laid it down. I know what she did. She laid it down. She didn't wear prints on. And I heard her talk. She laid it down in the water, and she took and just brushed some stuff over on top of it. That's what she's done.
Why did Jamie Darnell take the music group?
There might be a bottle. We don't know.
And remember that?
I remember telling me to get rid of that gun and make up a body on it. It came from A-Train.
Because A-Train has hands on it. And I remember when I told you guys about the other gun, I took it myself and threw that in my cousin's barn. Okay, because I was afraid he'd fire.
All right, pause here.
And I didn't want to keep the pistol around.
Did you emphasize with Mr. Dinsmore he had already thrown a .32 revolver away?
No.
Did you emphasize when he made this statement in relation to when the gun was found?
No.
Do you know how many days before this statement was made?
No, but it was made before the gun was found.
Do you know how many days?
No. A few weeks, a few days.
We're now going to go to minute 604 of this same exhibit.
Revolver, Shane, and A-Train, or Shane traded you a revolver? I remember Shane. I remember now that Shane traded me a black 38 revolver. And just a regular revolver, but it was when he switched the cylinder back 357. He came to me and wanted to get some pills for it. And I said, I can't remember how many I gave him. I think I gave him some one time. The next time I got some, I paid him off, for the pistol. But then we started talking, and we remember when Jamie Darnell moved in, was when Mom and Dad threw him out.
One gun, 38 revolver.
Yes.
Interchangeable 357.
Yes.
You made it seem like he mentioned possibly two guns. Was that a good question?
No.
Did you ever ask how is it that at one point Autry and Dinsmore both gave a 357 as the murder weapon? And then they both said at trial it was a 32 revolver. Did you ever connect that to the jury?
No, I didn't.
Why not?
I don't know.
You continually say you don't know.
Well, sitting here today, I do not know.
Would a competent, effective attorney had made these mistakes?
No.
You had poured your life into this case. What's going on? What was going on at this time?
I think at this time I wasn't prepared for trial. I thought we were going to get a continuance. I even thought when we showed up for trial on the day of trial in September that the other attorneys were going to ask for a continuance. I had been chasing all these other leads that they had dumped on us in May and July, and I was looking up like all these other witnesses. So instead of sitting down and doing my prep on the witnesses that were going to be the really tough ones that I should have done, I was trying to figure out who these unknown people were that were on the witness list. I was still reading through IRs trying to find the white truck, and so I wasn't prepared, and I had nobody in that trial. I did witness after witness after witness. If you watch, the state breaks theirs up among 4 different attorneys, and they take turns. Nobody goes twice in a row, or not very many times did they go twice in a row. I was going time after time after time, day after day, and I just wasn't prepared to ask good, hard cross-examination questions.
Keep going.
Well, I mean, I am a good attorney, and I did know the facts of the case, but just the way that it set up and it came to trial, it was a cluster.
On page 1542, you asked Mr. Dinsmore, page 1542. Line 4. So I'm not understanding. When did you and your wife talk, before or after Brent Booth came to talk to you May 18, 2017? Answer. We talked before, after. We talked last night. We talked on the way to court this morning. When did you and your wife talk about the fact that the white Nissan truck was parked in your shop? Answer. Before Brent came up. Question. Before Brent? Answer. Yeah.
So I did a very bad job when I went back and reviewed. I did a very bad job of pointing out that there was no break in that interview from the time he said there was no way that white truck was in my garage to the time that he said, oh yeah, now I remember it was in my garage. There was no break for him to talk to his wife.
Did you?
I didn't make that clear to the jury.
Did you ask for a recess and say the state has an obligation to correct perjured testimony?
No, and they had an obligation to correct it.
Did you ask for a mistrial?
No.
Did you ask for a mistrial at closing argument when General Nichols said the white truck was put at Victor Dinsmore?
No.
Why not?
I don't know. I had asked for a mistrial before, and the judge had just belittled me so much. I just didn't want another opportunity for the judge to belittle me in front of the jury. I mean, he treated me like a second grader over the evidence materials. When I said it was hearsay and the state said it's not hearsay, they're not offering it for the truth, and I asked for corrective instruction to the jury. He gave the jury a little mini lesson about hearsay, and he said every law student knows this. So every time I objected to things, he was so belittling to me that I thought I just got punished enough that I stopped making as many objections as I should have, and all kinds of hearsay came in, and all kinds of irrelevant material came in, and I should have objected to it.
When Brent Booth says, we got it right, you objected to his opinion.
Yes.
At the time of your objection, did you know that he had sworn to the Judge McGinley there was probable cause that Terry Britt committed the crime?
Yes, I knew that.
You had search warrants.
Yes, I knew that.
Why didn't you say, okay, you want to give your opinion, here's your prior opinion?
Gosh, I should have. I don't know why I didn't say that.
You had Terry Britt on a wiretap being told there might be a wire in this house.
So with the search warrants, I mean, I did bring up the fact that he had done hundreds of search warrants, and I did ask Brent Booth about that. But I should have gone through them each one and said, you know, you at one point said it was the Bobo family, and you at one point said it was Terry Britt. And all the different search warrants he had done for all the different people that he had sworn on oath that they were guilty.
The way Zachary Adams' prior attorney, is answering, it seems that she's accepting of the criticism from his new team, but will that impact the judge and the decision on the new trial in this case that's been requested? We have to get to a break, but before we go to break, we do have some breaking news out of Washington. A federal judge has thrown out indictments against former FBI Director James Comey and New York Attorney General Letitia James. The judge found that the appointment of the interim U.S. attorney Lindsay Halligan was invalid, who defense attorneys argued had no prior prosecutorial experience. Now, President Trump handpicked Halligan for the role amid increasing pressure to bring criminal cases against political opponents like Comey and James. We'll continue to bring you the latest developments as they come in. Stay with us. You're watching Court TV.
Tonight on Closing Arguments, tragedy on a cruise ship after the body of a teenage girl was found under a bed. We'll bring you new developments in the death of Anna Kettler.
Closing Arguments with Vinny Politan tonight at 8/7 Central, only on Court TV.
The disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage begins December 1st on Court TV.
Were you ready for the trial?
No.
Had you communicated to Zach that you did not feel prepared?
No.
Did you communicate to him that your mental health was declining?
No.
That is Zachary Adams' former attorney testifying at an evidentiary hearing that we're watching, and it's post-trial. She's saying that she was not prepared for the trial back in 2017 when her client was convicted in the kidnapping and murder of Holly Bobo. Now, Adams has now filed a request to get his conviction overturned. This comes after his co-defendant, Jason Autry, recanted testimony that solely got Adams convicted to life without parole. The defense is, of course, arguing that there was no other evidence that was concrete. Let's head back into the courtroom now and listen to more from Adams' former attorney. This is unaired testimony, Jennifer Thompson.
I should have been much more organized and laid things down like that in a solid. I should have just gone through one by one by one and just shown how the state had changed their theory of the case so many times. But, you know, it was hot in the courtroom. First of all, it was very hot those weeks. The jury was sweating. The judge kept saying, let's speed it along, let's move it along, let's get going. And
Did you ever make this point? Sheila Kilzer has a phone call. It reshapes the investigation, culminates in death penalty being requested after Dylan provides a 4-hour statement that's not true. But now, ladies and gentlemen, we're supposed to trust this last round of TBI's effort. Did you ever make that point?
not clearly, no.
Did you ever ask any state agent, tell me where the cell phone and the body was separated of Miss Bobo?
No.
Did you ever do the timeline of Jason Autry showing up at Shane Austin's house 20 to 30 minutes after the phone call at 8:52 and ask if Dylan's there with his shirt off the entire time, how is he taking the cell phone along the route that ends at Gooch Creek?
You know, I thought our cell phone expert was going to make that point, but clearly the expert didn't make those points to the jury clear enough for the jury to believe it.
Did you have a demonstrative aid, however crudely designed?
No.
The expert doesn't get to just pontificate. You got to ask questions, right?
Yes.
Did you ask questions to go through the rest of the morning to say, the state wants you to believe at 8:52 they have no idea what to do with the body after pulling off a crime that has escaped investigation. So they have to bring in Autry to drive to the river only to just come back, and at that point they say, well, that didn't work, let's go to Sonic. Leave the body at Shane's house knowing the satellite installer's coming. Did you ever work through this with the jury?
No.
Did you ever say for years TBI thought Holly was alive for several days?
No.
Did you subpoena the prosecutors and say, what are you going to give Jason Autry for this testimony?
No.
You asked for it in your Brady motion, didn't you?
Yes. Mike Scholl had told me what Jason expected to get.
What was it?
Little or no additional time past his federal sentence, which is what he got.
Did you ask Mr. Autry how many years are you willing to receive for your testimony?
No.
Mr. Autry repeatedly, when confronted with something, he would say, if your records show that.
Reflect, yes.
If your records reflect that. Did you ever ask, who told you to say that?
No.
Did you ever ask Mr. Autry, what was it like sitting through waiting trial for a death penalty case you didn't do?
No, I didn't ask him that on trial.
There were statements Zach made, correct?
Yes, there were statements that Zach made.
Did you talk with him about Zach? Did you talk with Zach about them?
No, Jim Simmons, I think, talked with Zach about the statements.
Did Zach tell you he wanted to testify?
I don't remember that.
Do you remember talking to the news after the verdict?
Not exactly. I remember that I walked outside and made some statements to the reporters, which was really about the first time I'd made any statements.
Did you ever prepare Zach to testify?
No.
Why not?
Well, because there were some accusations that Zach had tried to rape his stepsister, and I thought if we got him on the stand, those accusations were going to come in.
Did you discuss it with Zach?
No.
Do you ever allow your clients to testify?
Not usually.
How many clients have you allowed to testify?
Oh, maybe just one.
How many trials?
Many.
How can you make a decision as to the wisdom of the client testifying if you don't see how he does in preparing him?
Well, I guess I made the decision based on the fact that these accusations, which I did not believe, were out there, and I didn't want them to come in.
That's the only reason.
Well, also, Zach was a little methy. Even still then, he's not the man he is today.
You had been advised in these proceedings that there was shared in discovery a video from the ATM machine.
No.
In the post-conviction proceeding.
Oh, yes. I've now know that the state knew that there was a video of the ATM machine.
And did I ask you to follow the file path that was provided in a motion by General Boyano to find us?
Yes. Yes. So
we've got a situation here where the new attorney is questioning the ex-attorney, but are they essentially working towards the same goal? Let's talk about it with our guest who is here with us. Criminal defense attorney in Los Angeles, Forrest Miller, is here. It's great to see you, Forrest. Tell me what you're making of what we're hearing from this attorney on the stand. This is the defense saying she was ineffective as counsel, so we'd think that she'd be really defending herself, saying that she did the best that she could, but we're getting a different feel from her.
Hi, you're doing great after. It's great to be here. Thank you for having me. So yeah, this attorney is really falling on the sword here. There's a lot of holes here that she's admitting that she did not do, didn't have the timeline down, didn't point out certain things that some discrepancies that were going on between Mr. Adams and the other guys. It seems like there's a lot of holes, and IAC is two prongs. It's was there a deficiency in her representation, and did those deficiencies prejudice her client? And it seems like it did. So Mr. Adams here has a good chance that this could be overturned.
Yeah, we'll see what the judge says in this case. What about this point where she's saying that she didn't even bother to help him get ready to testify? We know that that's not really up to the attorney. The client gets to say whether or not they are going to take the stand. And she said, I didn't even prepare him for that.
That's kind of outrageous. You always try to at least talk to your client about if they want to testify, and then you talk to them about the strategy, why they should or why they shouldn't. You know, she just brought up some things about a potential accusation from a non-charged crime, which she absolutely could have gotten out of the trial and had it not admitted. So for her not to allow or even talk to her client about him testifying is an absolute mistake.
All right, Forrest, we're going to keep watching this hearing together. We have to get to a break, but when we come back, we're going to see some ATM surveillance video that's really pivotal in this entire thing. It shows Zachary Adams, but who does it help? That's after this quick break. Thanks for being with us. Welcome back to Court TV Live. Let's go back to Tennessee, where we are watching an evidentiary hearing for a man who was already convicted for raping and murdering a nursing student. This happened to Holly Bobo back in 2011, and one of the men convicted, he is looking for a new trial, an overturning of his conviction, because he says a key witness for the prosecution has recanted his testimony, which did happen. Jason Autry testified at trial that he saw Adams kill the victim, Holly Bobo, but now he says that he made it all up. So we're getting you caught up on all of this on-air testimony from this post-conviction relief hearing. On the stand still is a former defense attorney who was representing the defendant at the time, and she's getting grilled on how she handled his case.
The file path from BP 413.
No, I could not get it open.
And did you take a screenshot of what your computer had? You can look at the document been passed.
I guess I did.
And did you send it to me?
I guess I did. But recently, I mean, I did it just very recently, too.
Let me ask this. Would it help you remember when you possibly sent this if you saw the email to my office?
Yes.
I'm going to pass the witness this. Just look at it and then provide it back to the court officer, please.
Yes.
All right, provide it back to the court officer. And what date was the email?
April 25th, maybe, 2025.
And what's the date on the install this first to view on the far right?
Oh. April 3rd, maybe?
Okay. And is this what you?
Yes, this is the screenshot of it.
Your Honor, I move to enter this next numbered exhibit.
No. But I recently also got.
Go ahead.
Yeah, you recently what?
I recently, just days ago, got out the hard drive again, turned it on, fired it up, and tried to open the file on the Mac. It wouldn't open on the Mac, but then I made a copy of it to a thumb drive, took it over to my computer, installed the software on my hard drive like it says to install the software. The software went on and still couldn't open the files.
It was labeled, what is it labeled on this?
V8 or something like that.
But what's the individual date? The individual number.
I don't know. I lost my copy. Hang on. Oh my gosh, this is not a good copy.
What are the letters by the number?
BP, so it's labeled BP. BP 4-15.
And in the file path, what is it labeled that it's from?
I can't tell.
Okay.
But I think it looked like it was video from the BP store.
If it was, did you ever, let me strike that. Did you ever see the file path ATM?
No. There was some bank footage that they provided, and I did go through the bank footage and try to watch it and see if I could see Zach coming through an ATM. But I didn't, it didn't clearly show the ATM, and I didn't see Zach come through.
What? You could look behind you.
Which exhibit is it?
Exhibit 8, Your Honor. Do you remember seeing this video, Ms. Thompson?
This video right here doesn't seem to show anything.
Okay. Do you remember seeing it? Hold on one second. Okay. Do you remember watching this video?
Not specifically.
Okay.
Is it the video from the bank?
I can't answer questions.
It seems like it's the video from the bank where it's showing the road and showing cars driving up to the bank teller window.
Did you change computers or hardware at any time leading up to your representation?
No. I had a Windows computer in my office.
So in March and April of 2017, when you attempt, or 2025, this year, when you attempted to open, is it because you had a new computer, a new system?
Well, I did get a switch over to Windows computer years ago.
Okay. And if you could turn around. Do you ever remember seeing, prior to these post-conviction proceedings, this photo?
No.
Do you?
Which is a still shot of that exhibit. We marked it as a long exhibit what?
101.
101.
If you had the timestamp of 11/12 of that photo, would you have used it in a jury trial regarding the timeline the state sought the jury to believe?
Yes, that's an alibi, partial alibi for the time that the state says he was committing the murders.
Did you have photos of that Silverado from being impounded by the state?
Yes.
You testified you were competent and diligent as an attorney in 2014,
Yes.
2015,
Yes.
2016,
Yes.
2017.
I think 2017 things began to change.
Were you competent and effective at the trial in September of 2017?
I don't think so. I think that I was still trying very hard, but I think there was so much material, and I was the only one working with it. I was the only one doing the trial, and even if I had wanted to pull something up and play something for the jury, it would have been a monumentous task for me to find it in the discovery. One of the things that the state did is they would come up and they would present the witness with a piece of paper and say, here's this, and I would say, what is that she's handing him? And she said, well, she got it in the discovery, Your Honor. Well, I got 4 terabytes the first day. The first day they gave me discovery, I got 4 terabytes, and then they kept adding on and on and on to that. So I wasn't able to pull things in trial and show them. I was barely able to cross-examine witnesses. And it's not because I wasn't trying or I wasn't a good attorney. It was because the situation that I was plopped down into, and with the judge being so rough on me and the state being so ugly to me, it just made it impossible for me to be my normal, zealous self.
You know, some defense attorneys say being inside of these courtrooms, it's like a David versus Goliath situation. And we're hearing that from this attorney, just saying she was overwhelmed and dealing with a judge that was hostile against